Defendant's zipper was down and his pants were soiled. The lab determined his blood alcohol level was a point.
By my count, this is your true sixth drunk driving. What in the world is that about? 6 drunk drivings? The guidelines don't.
The chaos you just saw, that's the rock bottom for Mr. Herrera. But the real shock comes when the judge looks past the soiled clothes and realizes this isn't just a bad night. There's a secret in his record that changes everything. This is the sentencing of Mr. Herrera. His defense calls this a one-time slip-up after 16 years of sobriety. But something doesn't add up. How can someone claim to be remorseful while getting caught driving illegally again? While out on bond for this exact case, at stake is 5 years in prison. The judge has to decide, is Herrera a reformed man who stumbled or a permanent threat to everyone on the road? To see how judges spot the difference between genuine remorse and a practiced routine, hit subscribe. We break down the legal tells most people miss. Let's go back to the moment the sentence began.
It's file 25-7090FH. Counsel, you want to state your appearances, please?
Mr. Goodrich, Plain County Prosecutor.
And James Gilbert here on behalf of Mr. Herrera.
All right, and this is the sentencing on a charge of operating while intoxicated, third offense, 5-year maximum, and the DWLS 93 days, 0 to 6 guideline range. Have you had a chance to review the report and recommendations with your client?
We have, Your Honor. We have no additions or corrections.
All right, and any scoring challenges?
No scoring challenges.
Ms. Goodrich, any additions, corrections, or scoring challenges?
No, Your Honor.
All right, we also, I think, we did a show cause as well. That we were told that there was a problem with Mr. Herrera's soberling. Anything you want to report to me about that, Mr. Gilbert?
Your Honor, when I learned about that, it seemed like there was a logistics problem about trying to recalibrate it because my client's from downstate. I did have him get all his receipts that he's been paying for the SoberLink. He's been blowing in the SoberLink. There's been no things that have come back positive. It seemed like the person that services it wanted him to come up to Sheboygan. He said he couldn't do it right then because of the logistics. And however, there has been, like I said, he's gathered all his receipts, and since Friday, he's been making sure he takes pictures to show the court that he's not violating any order.
Do you know what it means in the affidavit to say that he wasn't cooperating and is out of tests? Do you know what in the world that means? How can you be out of tests on a SoberLink?
I wonder what that meant as well, but that was the communication from your office and their discussions with Megan Fenton about the SoberLink.
Okay, I just don't know what that means.
Right. I don't know without it being downloaded, whether he was maxed out that they couldn't download any further information would be my guess. Because he wasn't coming up to download the information.
Well, all right, well, we're here for sentencing. I don't really still know what that means, and if the prosecutor doesn't have any further information about what that means, I'm going to go ahead and dismiss the show.
Thank you very much, Your Honor.
All right, and Ms. Goodrich, you said you had no objections to the scoring as well?
No objections.
Okay. Go ahead with any allocution, Mr. Gilbert.
Oh, Your Honor, we're in favor of the recommendation. I know the court was concerned about the priors and with being a third offense. However, I would point out that the last OWI that my client had, it was 19 years ago or 18 years ago. It has been a significant amount of time. And talking with my client, it's an issue that he has addressed. He'd sort of gotten away from it, that his sobriety, and thought he could handle it. And obviously that turned into this conviction. He understands that, and I believe stands before you very remorseful for that, and has implemented the things that he was doing for the 18 years so that he was in control of any type of alcohol consumption. I believe that he has learned in the time period that I've been representing him. I mean, he hasn't had any issues where he's been using. He hasn't tried to cheat on the SoberLink. He stays active, trying to focus on things around his farm and that type of thing, so that he doesn't drink. He says he's got it under control, like he had for the years before. This was an 18-year slip up. I don't believe you're gonna see him out again, and I would ask that the court minimize any type of incarceration. Understand there's gotta be an example to the community. However, I don't believe Mr. Herrera is a huge threat any more than anybody else out there to public safety. You know, again, granted, his history is there, but it is substantially old. And I would ask the court to take that into consideration. Again, he's been on bond for quite some time and has had no issues. Thank you.
All right, thank you, Mr. Herrera. You don't have to make a statement today, but you're allowed to. Is there anything you want to tell me or not?
Yes, deeply ashamed the actions that's brought me here today. Very ashamed of the burden that this is putting on my wife and will continue to put on my wife. And I fully accept accountability for those actions that brought me here today.
Thank you. Ms. Goodrich, any recommendations from the people?
Yes, Your Honor, we are here because on September 13th of 2025, the defendant was found unconscious behind the wheel on South Straits Highway. He had multiple empty cans of White Claw surrounded by him. Law enforcement instructed the defendant to put the vehicle in park. The defendant responded by grabbing his sunglasses on the dashboard. The defendant's zipper was down and his pants were soiled. The lab determined his blood alcohol level was a 0.280 over 3 times the legal limit. He's 58 years old. His first arrest was at 20. He had 0 prior felonies and 7 prior misdemeanors. There is a 16-year gap in his criminal history. He was in jail 1 time, probation 2 times. He's unemployed. He did complete a substance abuse assessment during this case, but I was also surprised to see in the PSI that he was convicted of DWLS in Charlevoix County while on bond for this case. That was missed by us. He does have 5 prior OWI related offenses. His last one was in 2007. He explains this behavior that after 16 years of sobriety, it was broke while he was trying to self-medicate with health issues he was having. Based on his driving while license suspended conviction and having 5 priors, I don't believe that the 30-day minimum for this offense is appropriate, that it should be 60 days. Thank you.
Mr. Herrera, by my count, this is your true 6th drunk driving conviction. When I look at the history there, in 1988, you had an OUIL in Arizona, got fines and costs. 1989, same thing, Arizona, fines and costs. 1993 in Gratiot County, it was unknown sentence. 1998, your 4th. In Grand Traverse County, you got probation and fines and costs. You had a suspended license charge in 2003, fines and costs. 2007, your 5th drunk driving in Grand Traverse County. You got sobriety court. You did a whopping 21 days in jail for your 5th drunk driving. You successfully completed your sobriety court, and there is a 16-year gap. That's good. I want to tell you, but for that 16-year gap, I would most likely be sending you to prison today. 6 drunk driving convictions. The guidelines don't take into account the fact that this is a 6th conviction for OWI, nor for the pattern of drunk driving, committing the same offense over and over and over and over again. They also don't adequately take into effect that you were convicted of suspended license while this case is pending. What in the world is that about? While you got this case pending, then you're driving on a suspended license in Charlevoix. I'm not telling you, 6 drunk drivings, the guidelines don't matter that much. 6 drunk drivings. So if you didn't have that 16-year gap, I promise you, today you'd go to prison. But given the 16-year gap, I think it's reasonable to not send you to prison. So I am going to place you on probation. It's going to be for 3 years. The probationary order can include just the OWI charge if you want, the felony charge. We'll put them on probation. Yeah, it'll have to because it's 3 years. So that'll be subject to the terms and conditions on pages 2 and 3 in the pre-sentence report, including support group meetings and treatment as your field agent recommends. You can't drive without a driver's license. You have to get and keep a job. You have to do 60 days of community service. There's a crime victims assessment of $130, court costs of $350, $93.18 OUIL reimbursement. There's $118 in state costs. You have to comply with DNA testing and pay a $60 fee, and I'm going to assess $500 fine. And then in terms of the jail, I do think that the guidelines don't adequately take those things into account. 6 drunk drivings really calls for a totally different change. It looks like in the past, you haven't gotten a whole lot of jail, and that hasn't done the trick. We're still here on your 6th conviction. So you're going to do 1 year in the Sheboygan County Jail starting today, credit for 3 days previously served. On the DWLS, it'll be 93 days, credit for 3 days previously served. I will approve you for participation in the CBT program, classes in the jail that can shorten your sentence, as well as the jail's trustee program that can shorten your sentence if you're eligible for that. That is a departure from the advisory guidelines. I've set forth my reasons for the same. I think it's proportionate to the seriousness of the circumstances of the offense and offender. If you want, you can petition for early discharge from probation at the halfway point if you've successfully completed its terms. So we're going to hand you a piece of paper explaining that. Also, you can appeal to the Court of Appeals if you wish. If you want a lawyer, you have to ask me within 6 months. We're going to hand you a piece of paper explaining that. Ask you to initial 1 copy for us that we have a record we gave it to you, and the other one is for you to fill out if you want to take an appeal. Within 24 hours of release, you have to contact your supervising agent. You have any questions for me, sir?
No, sir.
If you violate probation, I will be sending you to prison.
Okay.
Good luck.
The gavel finally fell. The judge sentenced Mr. Herrera to a full year in jail, followed by 3 years of probation. But here's the real question. Does a 16-year gap of sobriety erase the danger of a 6th offense? Comment below, Team Mercy or Team Public Safety? Was a year in jail enough, or was the judge too lenient? If this case got you thinking, hit like and share.